And Amy and I are going to be tag teaming this. Each of us will do a section and probably comment on the different sections that the other person is doing. If you'll go to slide 2, this is kind of an outline of the topics that we have today. And just for your, if you want to know what slides address which issues, we've got the slides labeled. Amy will be doing the first 2 sections. I'll be doing the 3rd and 4th, Amy the 5th, and I'll do the final one, what's next. So with that being said, let's get started with the COVID-19 related pay leave. Amy.
Very economical as well as a way.
Okay, so many of you, especially if you're employers and employees, have had to navigate a lot of the new rules this year and the new laws with respect to paid leave when COVID-19 is involved. The 2 most relevant divisions of the FFCRA, the Families First Coronavirus Response Act, are the ones that we're going to address today, and those have been the most common instances with our employer clients in trying to figure out whether someone qualifies and for how long they get the leave, how testing comes into play, things like that. So the Division C covers the FMLEA. Those of you who are familiar with FMLA, this is the expansion act of FMLA related to COVID. The Emergency Family and Medical Leave Expansion Act is the official name of that one. And then Division E of that FFCRA covers the Emergency Paid Sick Leave Act, EPSLA. We refer to them by those shortened names just to kind of get through. Okay, so first we're going to address the FMLEA. This is 12 weeks of job protected paid leave, and of which the first 10 days may be unpaid. Between FMLA, the regular FMLA leave, which you all know is 12 weeks, and this expansion act, the FMLEA, you get a total of 12 weeks between the 2. So if you have an employee who's already used up some FMLA for the year, however you're counting that year, keep that in mind when you communicate with those employees about granting them additional leave under the FMLEA. The leave, as the slide indicates, benefits all employees who've been working for at least 30 calendar days. It's kind of a low threshold, certainly lower than the FMLA, so keep that in mind. And then the reasons for the leave are that those employees who are unable to work or telework due to a need for leave to care for the son or daughter of that employee, if the school or place of care has been closed or the child care provider is unavailable. This came into play in a major way earlier in the spring when there were stay-home orders and all the daycares closed and the schools closed. Now things are opening back up. Oftentimes school is back open or you're at home virtually learning. And so you need to figure out if your employees qualify for this leave, if those schools are closed, or if their day cares are not available. One thing that the Department of Labor certainly emphasized early in the year, and I'm sure is going to be a good idea for the remainder of the year when this is in place, is work with your employees. If there's a way for them to be at home with their kids because their schools are closed or because they need to get them through virtual work and work from home, try to set them up with that. If there's a way for them to put in some hours, come in a half day, and then be home in the afternoon so that they and their spouse can kind of manage that, try to work those things out so they don't have to use the leave. And so you have productive employees who feel more valued and feel like you're going to be flexible with them, because everybody's got to be flexible during this pandemic. So that's kind of a lot of the discussions we're having with employers about these leaves. Remember that the first 10 days are unpaid, but if they also qualify for that Emergency Paid Sick Leave Act, they can that amount can be used for those first 10 days, or they can use their own paid time off if that's available to them. Also remember that the amount of pay is not less than 2/3 of the employee's regular rate. for this paid leave. And then you see the thresholds, $200 per day and not more than $10,000 in the aggregate. This applies to every employer who has fewer than 500 employees. We know many employers who are fewer than 50 employees who aren't used to having to allow the regular FMLA and who have asked us, gee, do we qualify for an exemption? And there is an exemption. If you meet certain criteria, it's spelled out at the Department of Labor page, or we can help you through that. Essentially, if you aren't going to be able to feasibly run your business, and you can demonstrate that, and you have somebody in your business who would be able to state that outright, you can sort of follow through on that exemption and not allow this leave. But make sure you're sure that you're willing to say that before you refuse to provide the leave. Now, with respect to the EPSLA, the Expanded Emergency Paid Sick Leave Act, this is the 80 hours of paid sick leave. Employers are required to provide the leave for 80 hours for full-time employees and sort of a prorated amount for part-time employees. Employees do not have to be employed for any certain length of time in order to be eligible for this paid leave. And here are those 6 reasons. Many of you have had to study these 6 reasons for whether your employees qualify for the paid leave. These are important reasons to understand. They're detailed quite a bit on the Department of Labor question and answer page. Keep the first 3, we kind of categorize them as the first 1, 2, and 3, and 4, 5, and 6, in particular 4 and 5 are kind of linked together as well. The first 3 are about the employee. If the employee, him or herself, is experiencing symptoms or has been advised by a health care provider to self-quarantine, or is subject to a local quarantine or a federal state quarantine, they may fall in that category. If the employee is caring for somebody in one of those categories, that's number 4. And then if they're home with their child and their school or daycare provider is closed, that's category 5. And then that 6th category, 6th reason for leave, is described as experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Treasury and Labor Secretaries. That's a pretty broad and somewhat vague provision. You want to be really careful that you look at that and see if there's any way that your employee might fall into that category before you refuse to honor their request for paid leave. Go ahead,
Amy,
Kristen.
I have had a question here. Bob Stevenson just asked, does FMLEA and EPSLA apply to churches?
Bill, do you know the answer to that question?
I believe the answer is yes, because
Yeah.
I'm not aware of any exemptions from these 2 laws that exist for nonprofits or religious entities.
Okay, thank you.
Mm-hmm. But if you have a really low number of employees in that church and you want to try to apply for the exemption, one of those exemptions, or state your exemption, that's also an option if you don't feel like you can run the church and the necessary services without, if you had to honor this for every employee that might become eligible. Good question though. Okay, with respect to this EPSLA leave, the 80 hours of leave, the amount of pay depends on which of those 6 criteria you fell into. So if it's you as the employee who is having those symptoms or have been told by your healthcare provider to stay home or under a specific issued quarantine, then you should be awarded your the full amount of your pay. If you fall into the categories of 4, 5, and 6 on that previous slide, whether you're caring for a child or caring for another individual with COVID-19 or with those symptoms, or that substantially similar condition, then you get 2/3 of your regular rate as pay. And then as lower in this slide, you'll see that we've identified them in green. It cannot exceed $511 per day with a $5,100 aggregate for 1, 2, and 3, $200 a day, $2,000 in the aggregate for 4, 5, and 6. So one thing, once you kind of compile those two laws together, what you realize is that you could, certain people may qualify for both. If you're a parent of a child whose school or place of care is unavailable, then you may qualify for the 10 weeks of FMLEA, plus the first 2 weeks could be covered under the EPSLA. Of course, if you're caring, go ahead, Kristen.
We did get another question here. Julie Munson asked, what about employees who've not been exposed, have no symptoms, but just want to get tested? Are they responsible for paying for them? And are they excluded from work?
I would say that if they're volunteering to get tested without a doctor's suggestion to get tested, then it probably doesn't qualify as having a healthcare provider's direction. Bill, do you agree? We've had those questions.
Yeah, I agree with that. And especially if the employee has no reasonable belief that they've been exposed, it's not the employer's burden to treat that employee as if they've been exposed.
Michelle Fairchild also followed up that question is, you require some sort of proof from the employees? Or I think, let's see, can you require some kind of proof from employees? Like, can you ask them to say that this is where you went and why you want to be, I'm assuming that's what she's asking, why you want to be off work.
I've been suggesting to our clients that there's specific criteria that if the employer wants to be reimbursed for some of this pay for the leave, they have to have some certain information from the employee. What school was it that has been closed? So oftentimes you can look that up, especially in the spring. We knew that every school pretty much was closed. Mm-hmm. If they can get a doctor's note and give them time to get that, certainly when everything was shut down, you needed to allow additional time because doctors were quite busy. They may be quite busy this winter too. So, but doctors have oftentimes can send a note that said, I directed my patient so-and-so to get a COVID test, or these are the results of the COVID test. There's certain documentation certainly that you can request and that you may need in order to request that reimbursement later.
Great, that helped that you answered her question. Thank you.
And from another perspective, I was going to touch on it later, but since this question came up, after the fact, if an employee claims that a spouse, a child, or somebody in their family has been exposed or has COVID, you should contact or will be contacted by the Department of Health for your county about contact tracing. Mm-hmm. One way to verify that the person, yes, did have COVID or was exposed to COVID or was quarantined.
Great, thank you.
But that's an after the fact finding, not one up front when they're trying to take leave.
Mm-hmm. And the earlier you can set up a good system of what's your checklist of things that you request from everybody so that you treat everybody fairly. Everybody knows that you're requesting the same information from each person in these scenarios. And you can check those boxes as you go. The more you'll be grateful for having that checklist later when you have to figure out when you awarded this pay and when you refused it and why, and maybe they didn't come up with that documentation, and they didn't have a good excuse for not coming up with that documentation, or they voluntarily just wanted to get a test to see without having that exposure.
Great.
Okay. So now we're moving into sort of how you're adjusting the workplace in addition to those paid leaves. Many HR departments know that trigger word reasonable accommodations, and whether COVID has sort of changed what reasonable accommodations mean now that we're working differently, and possibly telecommuting, and how that could change. The answer is yes, it could change what a reasonable accommodation means if you're operating during a pandemic versus hopefully when this is over sometime next year. It could become an undue hardship to continue to allow employees to telecommute after the pandemic is over. If for example, if you've instructed employees to stay home because of the pandemic and have set everybody up to telecommute, once things start coming back to normal, you may be able to assert that having everybody telecommute is now an undue hardship. We need everybody to be back in the office to meet with customers now that we're reopening, things like that. I recommend that you tell everybody from the outset that we anticipate that everyone telecommuting, or certain people telecommuting, is a temporary thing that will be in place for as long as necessary, potentially through the entire pandemic, but everybody needs to know from the outset that this is temporary. In addition, well, we kind of hit that requiring telework now doesn't necessarily mean that they will get that as a reasonable accommodation later. And that if you have an employee who had requested to telework before COVID hit, and now is teleworking because everybody's required to, or because that it worked out for that position and you made arrangements for that person to do so, what you need to keep in mind is once the pandemic is over, they may reassert that request for a reasonable accommodation to telework. And now you've put into play whether teleworking worked for that employee. If that employee was able to be productive, was able to get their work done, and was still able to do all the essential functions of their job while teleworking, you may need to reconsider whether that teleworking request could be a reasonable accommodation now, because you've tested it. So keep that in mind. It can't just be, the pandemic's over and now we go back to the way things were. Now that employee has had a chance to prove him or herself by teleworking, and they may be right that they were able to get their work done really well at home. So put those systems in place. Be really clear about your communication that you anticipate that this will be temporary, but you need to also reevaluate things when it's over, if they still want to telework.
Just another note on, can you go back to that prior slide, Amy?
Mm-hmm.
I know a lot of you, when you see the words reasonable accommodation or reasonable accommodations used together, you think about the Americans with Disabilities Act. And I am starting to see more and more discussion of COVID-19 or the coronavirus in the guise of being a disability. It currently is not, but I think, especially if we have an administration change out of Washington, we could see new guidance or regulations that get from its current status to be a disability. So that is something to watch for in the very near future. And it may impact how you treat your employees. It is not considered a disability now, but I read another article that indicated that just this morning, that indicated that there can be some permanent lung damage or even some permanent cognitive damage associated with COVID-19. So I think everybody that's listening ought to put it on your radar that this could become a disability and therefore covered under the Americans with Disabilities Act, or the Ohio Revised Code for those who have fewer than 15 employees for the protection of individuals with disabilities. So just put that out there on your radar and pay attention as we all are.
Excellent point. Okay, a lot of employer clients have been asking, can I require that my employees get a COVID-19 test? The answer is yes, if it's, quote, job related and consistent with business necessity. If you have everybody teleworking, you don't need them to get a COVID test. That's the job related part of it. And whether it's consistent with business necessity. Are they coming into the office? Are they potentially exposing others? Do you know whether they have had an exposure and you want them to be free of COVID via a test, with proof via a test, versus just waiting out that period? It seemed like this was kind of a no-brainer to a lot of people until we realized that testing was taking almost longer than the quarantine period. So sometimes it was just an easier option to allow employees to wait out that quarantine period before letting them come back, even if you didn't require a negative test to return. You just make sure you keep up to date with CDC guidance. It's been changing a lot this year with regard to whether testing is an accurate assertion of whether you have COVID-19 at that moment or not, and then apply it to everybody consistently. You either apply it to all those employees in the category that requires that business necessity, or you don't, and you don't get to pick and choose which employees get tested and which don't, as long as you just have to have that same criteria. Okay, so so these are some kind of basic rules to follow that have interesting distinctions that would be easy to mistakenly fall into just because of the way we interact with our coworkers and the employees in your employment situation. One distinction is you can ask an employee if they've been in close contact with any persons diagnosed with COVID-19, or if those persons who have or if they have had symptoms associated with COVID-19. But you're not supposed to ask if anyone in their family has COVID-19 or anyone in their family has COVID-19 symptoms. So try to make that distinction, especially if you are drafting written documents or written questions, or for example, in our office, we do an online survey every day to make sure that everybody that's showing up for work or intends to show up in one of our offices hasn't experienced symptoms and has not had close contact with any persons diagnosed or symptoms of COVID-19.
Amy, just a quick question. Robin Ridge asked if the slides today will be made available to everyone that attended.
Yes, I believe our Kathy Rohde has already made them available at rcolaw.com, or you can go there right after. I think she's already provided a link to this slideshow. Wonderful, thank you. Yep. Okay, another sort of do this, not that guideline. When it comes to informing coworkers, you've had an exposure and somebody calls you and said, okay, I've been exposed. You do want to inform everybody else of their potential exposure to COVID-19, but you shouldn't use their name, the employee's name who's been exposed. And if that employee needs to start a quarantine, you shouldn't explain that, oh, well, that employee is home because they're quarantining. You just have to kind of pull it back and use that general descriptor. We all know that they may figure it out, but just because they may be able to figure out who's here and who's not, or if that coworker talks to other people about their exposure, that's their business and they can do that. But you should not, as the employer, announce which coworker has COVID-19, since everybody's going to find out anyway. And you should also not keep it a secret. People are not going to like it if they find out later that they have a potential exposure and you didn't tell them. The best policy is let everybody know right up front at the earliest possible point, including figuring out from that employee with COVID or with COVID symptoms, can you tell me who in the office or who in your employment environment you were around the most that maybe I should go to directly and say, we think you may have been exposed. Someone in this area has COVID symptoms or now is COVID positive, and you need to know, and then you go from there. Just like everything else in employment law, consistency is key. So you want to require the same medical screenings and inquiries of all your employees. You don't get to pick and choose that certain employees are going to be tested and certain other employees you're going to trust that they're just going to monitor symptoms. You need to apply everything across the board to all employees that this affects. In addition, one thing that a lot of our clients were faced with was they might send everybody, they had to close down or they had to lay off a lot of employees in the spring, March and April, May, and now they're in the process of bringing people back or reopening. And we had clients who said, I have some employees who I know are vulnerable to COVID, can I just keep them home? And we had to say no. You have to treat everybody, whether they have a disability, whether they are over the age of 65 or in any kind of vulnerable group to COVID. You have to allow them their chance back at their job. Now, if they say, I have a disability or I don't want to come back to work, then you have to take the next step and kind of discuss that with them and see what you can work out. But you don't get to choose which employees you believe are more vulnerable to COVID, and that's how you're selecting how to bring back employees. Okay, I think it's up to Bill.
Well, moving on to the unemployment section of today's presentation, we have found over the past 6 to 8 months that unemployment has been a much greater issue for employees than employers. And if you are having problems as an employer, these are the acts and the acronyms that apply to your workplace. But Amy and I have both fielded calls from employees who are getting caught into the morass of the Ohio Department of Job and Family Services. And what we're finding is there's just a lot of frustration amongst employees because of delays associated with their claims. And we've had some folks in our office back in March and April who had a lot of difficulty getting unemployment during a brief layoff period. So if you're experiencing that, just tell your employees that you will work with them, you will cooperate with them, you'll help them in any way with their claim with the Ohio Department of Job and Family Services, but try to stay out of direct contact. And understand that most of these benefits are scheduled to end or have already ended. Under the CARES Act, this is supposed to end December 31st of this year. But again, as the political winds shift, some of this may be extended, it may not be extended. Stay tuned. All I can say is I've heard this COVID situation described as a fluid situation. And to me, that's about like saying that Niagara Falls is a bit moist. To say fluid is an understatement. It's changing constantly. And be aware that tonight, Governor DeWine is having a press conference at 5:30. Things may change again at 5:30 today. We don't know. But back to the unemployment benefits, the PUA was the section of the CARES Act which provided the additional benefits and leave benefits to people who typically do not get unemployment because they're normally 1099 employees rather than W-2 employees. That includes people who are self-employed gig workers or who have otherwise exhausted their leave benefits. So the PUA under the CARES Act gave benefits to people who normally don't qualify or are not eligible for benefits. The second piece of this puzzle was the PUC, the Federal Pandemic Unemployment Compensation, or the FPUC. This applied from March 29th to the end of July. Now, this was the subject of a lot of debate in Washington in August and September. Nothing came of it. There was no additional relief granted to employees under either or under this particular program or any of these programs. So be aware that this could also change.
Bill, I have a quick question for you. If the employee lives in Michigan but works here in Ohio, who do they file unemployment with, Michigan or Ohio?
Where the employer is where I would certainly start.
Okay.
Because that is their place of employment, and that's where the unemployment taxes would be paid.
Okay, thank you.
Yeah, I think the terminology is where they work. And so the answer is the same, Ohio, it sounds like, in that scenario.
Great, thank you.
Mm-hmm.
And for those employers out there who had furloughs or layoffs or may still have them, the situation came up because of this extra $600 per week under the PUC, the middle item on this screen, where individuals who were on layoff were receiving more in compensation being off work than the folks who stayed at work and actually worked. And it can create a lot of hard feelings. And we may get back into this situation again if additional benefits are granted in the future by Congress and the administration. We don't know where that's going to go. One way to remedy that, or to at least address it, is to somehow recognize your employees who stayed employed and consider a bonus, extra time off, something to recognize that, yes, we understand that you are making less than the people who are staying home. And that's a real problem. And it's one that was placed upon us by the federal government. There isn't anything we can do about it, but try to deal with it with our employees. So I would say communicate. So again, this was a March 29th to July 31st program. Right now it's at rest. It may come back. So that's why I put it in that's why this section is in the presentation. The next section is the Pandemic Emergency Unemployment Compensation, a PEUC. This just added additional weeks of benefits to unemployment, and this is set to expire at the end of this year also. Now, again, subject to the political whims of Washington, D.C., this may change. All of these programs, as you can see, ended either at the end of July or at the end of this year, and they may or may not be extended. So all I can say is stay tuned, and we'll give you some links a little bit later as to some good resources to pay attention to. So these were the 3 unemployment programs under the CARES Act that was passed back in late winter, early spring that impacted your place of employment and every place of employment. Amy, if you'd go to the next page. All right, this page addresses the LWA. I don't know if you've heard of it, but it's the Lost Wages Supplemental Payment Assistance Program. This was not a part of the CARES Act passed by Congress. This was an executive memorandum signed by the president on August 8th. It's a very unique way of getting additional funds to unemployed individuals, but Ohio was approved for an additional $300 per week for a 6-week period, and they call it weeks ending August 1 to September 5th. Now, whether this LWA program will come back or not, I don't know. I doubt it because it was an executive action and not an act of a federal act of all branches of government, or the legislature and the administration, like the CARES Act. This was an effort by the executive administration to get extra money directly into the hands of people. I think prior to the election, it's $300 per week. It makes a big difference to those receiving it, but it was for a very limited time period. Will this come back? We don't know. Stay tuned to the political whims. So there actually were 4 unemployment programs available, 3 under the CARES Act and 1 by executive memorandum. And if you're not confused, take a look at this chart. This is from the Ohio Department of Job and Family Services. And this is available on their website, but I wanted to put it in the materials if you wanted to look at it later. This was kind of the path for receiving unemployment compensation. I'm not going to go into detail here, but if you want to look at it on our website or on this, or in this PowerPoint, or on the Ohio Department of Job and Family Services website, feel free to. So if you feel like you're not understanding everything with unemployment compensation under COVID-19, this will clear it all up real quick. Now, always apply the default rule, which means that if somebody refuses to return to suitable work, they are not going to be eligible for unemployment compensation. So you have to pay attention to when their leave periods expire, those dates that were on the prior slides, and understand that if somebody is refusing to come back to work and work is available and they do not have a medical excuse to not come back to work or other reason to not come back to work, then they can be denied benefits from the Ohio Department of Job and Family Services. And I think we'll see some litigation about this in the coming months, although we have not yet. So it's just a point to remember that they do have to come back to work. This is not a permanent vacation. And then also be aware of Governor DeWine's June 16th, 2020 order, and that may change tonight, but it had some specifics in it about not preventing eligibility under the 5 circumstances listed on this page. Again, I'm not going to go into each one individually, but understand that there are some exceptions to every rule, and this order applies to unemployment and somebody's refusal to return to work. So there are exceptions. Here they are. Won't read them to you, but you're free to look at them in the slide, or again, go to the Ohio Department of Job and Family Services or ohio.gov and look for this executive order. Kristen, you look puzzled.
No, I'm just reading some of those, and some of them look a little subjective to me. You know, it's.
Well, unfortunately, that's what keeps lawyers busy. Because what's reasonable to an employer is certainly not what's reasonable to an employee. And that's why we call the Americans with Disabilities Act the Aid to Dependent Attorneys Act, because you're arguing over what's reasonable in many cases. So you're exactly right, it is subjective. Now, getting into the testing and safety guidelines, I started doing the research on this about a week ago to see where we were with guidelines. And frankly, there were so many out there that were applicable to so many different industries. I thought the best thing I can do is to give you access to the various starting points to look for your particular industry. And I think the starting point for all of you as to safety guidelines and testing guidelines, both for employees and customers, if you are a retail or outlet that has customers into your place of employment, start with your local county health department. And I've given the Lucas County, Wood County, and Hancock County links there. I know we have some folks from other counties. I'm sorry they wouldn't all fit on one page, but I put the primary ones that will cover the folks viewing today. But start with your health department. And frankly, I would encourage you to call your health department, introduce yourself, and get a relationship with somebody at the health department that you can call with questions. Because again, this is an ever-changing situation and your health department's on the front line. So go to your health department first. And that will apply both to the safety guidelines for your employees and for customers. The second place to go is Responsible Restart Ohio. That is the general Ohio state, or the state of Ohio website addressing the COVID crisis. And it has a lot of information and a lot of links in it to some of the other links you see on this page and to industry specific information. Because if you're in healthcare, it's going to be somewhat different than if you are in retail, and that's going to be somewhat different than if you are in manufacturing or in the food industry. So that is a good place to start for your safety and testing guidelines also. The next place I would go is the Ohio Department of Health website. And the link I gave you was to their checklist for businesses. It's not their homepage, but this link also links to a variety of different industry-specific safety and testing standards for employers relative to their employees and customers. So we've got each county health department, the state of Ohio, and the Ohio Department of Health. 3 very good resources. And those are on more of the local level. At the federal level, the Centers for Disease Control is probably the most important on the COVID itself front. And I've given you a link there, which is to give guidance to businesses as to how to handle the COVID crisis. The next most important agency, at least from the employment standpoint, is OSHA. I'm sure you're all familiar with OSHA. And the 2 links I've given you there, the first one is news and updates. OSHA has started within the last few weeks updating COVID information via press releases. And I would encourage you to go look at their website for their press releases for these updates, because that's a good way to stay current. Now understand that OSHA is a division of the Department of Labor. I did not give a Department of Labor link here, but the Department of Labor itself is a very important agency in this process. OSHA is just one of the entities under the larger umbrella of the Department of Labor. And then the second link I gave you under the OSHA guideline is about prevention and control and trying to reduce risk in the workplace. So look at any of these links on this page. It's a lot of material. Each of these links will have multiple links to other links. It's almost being on a hamster wheel. Once you start running and start linking, going to hot links, going to more hot links, you'll find you've gone around the world about 3 times and you'll end up back at the same place where you started. So focus on your industry and the information that you need and try to stay out of the weeds, which is difficult to do now, but try to focus on your industry, and that's the best place to start. And that's after you call the county health department.
I will kind of back that up a little bit. The Responsible Restart Ohio is, like you said before, is a great resource. And they have a lot of graphics that make things easy to follow through, and even maybe worth posting depending on how many employees you have. You know, this is coming straight from the state of Ohio, and employees can sort of follow along and use that as a resource as well.
Yeah, and one of the reasons I encourage employers to follow what these agencies say is because it's the agency decision. You're following the law and guidance of the government, not doing things randomly on your own. That gives you a pretty good defensive position in the event there's trouble later. Mm-hmm. Now, the most important line on this page is probably the last one. Remember the OSHA General Duty Clause. And for those of you who are not familiar with it, I'm going to break all codes of giving webinars, and I'm going to read a sentence to you because this is critical. It says, and this is right from the United States Code dealing with the Department of Labor and the OSHA Act, it says each employer shall furnish to each of his, obviously very old, each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. Now, with that being said, that throws the burden on to all of you to keep your employees safe under OSHA guidance and OSHA law. Without regard to any other laws, you've got to keep them safe in the workplace. So that's why the safety and testing guidelines are very important, because in the end, you can be held accountable just by OSHA if your employees are contracting COVID in the workplace. So remember that general duty clause. It's good to know for these purposes and other purposes as well.
We have one question here, Bill. Do you have any resource links for Michigan employers?
You can go to the LARA website, LARA website. I believe, I mean, we can certainly, you can reach out to me. I'm licensed in Michigan, and aluck@rcolaw.com. You can shoot me an email and tell me what specifically you might be interested in, and I can look that up for whoever's asking.
Great, thank you.
To our Michigan attendees, I apologize. I did not know we would have anybody from Michigan, or I would have listed some of the Michigan resources.
Mm-hmm.
I go to the Michigan homepage, and my guess is, I have not been there for several weeks. Go to their homepage, and they're going to have a link to COVID resources.
Yeah, their setup is a lot different than Ohio's. I like Ohio's marketing department, or whoever's handling their graphics and things like that. I do feel like it's a little bit easier on the Ohio websites to navigate than Michigan's. And to Kristen and Bill's point about posting especially some of the Ohio stuff that seems pretty basic and easy to read and easy to follow. Not only does that demonstrate to employees who are maybe resistant to following the rules that these are the rules we got to follow, and we're following them, and we need to enforce those rules, and here they are. And it's not us making these rules, it's the state of Ohio. It also helps those employees who may be nervous about whether you are following the right rules, and you can demonstrate that in fact you are, and you post them. So I think it helps for both types of employees who
Yes, it does.
are always together in the workplace.
All right, Amy, if you would. This is from ohio.gov, and this is what they call their responsible protocols. And I think this is one of the illustrations that Kristen was talking about. They have some guidance, and if I had to put in one page and summarize everything I've looked at over the last week or two, this would be it. This is one page that gives you the general guidance on how to run your business and how to keep your employees and your customers safe. A lot of it's good common sense, but again, like Amy said, if you have employees that are questioning why you're doing what you're doing, go print this out from ohio.gov, and the exact website is under the Responsible Restart Ohio, and show this to your employees, because every workplace has got the ones who are hypochondriacs and are sure that they are dying of COVID right now if they have the sniffles, and others who actually have COVID who are too tough to admit it and too tough to ever be stopped by a disease or a virus. So you have both ends of the spectrum you have to deal with, and this is a good way to deal with them. Show them the Ohio responsible protocols.
Okay, and so if you're following those rules, then you may be able to avoid litigation in the future. And many of you have probably heard about House Bill 606 that was recently passed, I think late summer, early fall. I think early in the fall. Essentially, it grants that state law immunity from civil lawsuits for injury, death, or loss related to the transmission or contraction of COVID-19. The law defines who this applies to extremely broadly. This is immunity from civil lawsuits against any person. That could be a public entity, a private entity, a small business, a large business. It kind of includes just about everybody. It is effective retroactively from March 9th of 2020, and it goes through next year on to September 30th of 2021. So hopefully by then, COVID-19 will be under control to the extent that they don't need to extend this immunity from the transmission or contraction of COVID-19 in the workplace. Now, if you can use this immunity against civil lawsuits from both employees or customers, as long as you can, as long as they're not able to show that you were reckless, intentional, or willful or wanton conducting misconduct resulting in exposure to the transmission or contraction of COVID-19. So if you can show that you were posting those rules and that you were enforcing those rules that were put in place by the state of Ohio, by the local county, by the CDC, that's going to give you a great defense under this, under House Bill 606, to a civil immunity from those lawsuits. So much, I think the more the pandemic goes on, the more we're learning about how it's spread. You certainly don't want to spread it in the workplace. You don't want it to spread in schools. That's a big deal to many parents. And I think what we're finding is there's a lot of it spread in the community, and it's spreading so much that we can't tell where it's being spread necessarily. So, but the more you can do in the workplace, it makes your employees feel more comfortable, and it will also help you if you want to avoid a lawsuit in the future.
And just a comment on that, to Amy and I, the words reckless, intentional, willful, or wanton mean something different than they would to all of you. You live in a world of common sense. We live in a world of law and courts, and the two really don't go hand in hand, in my opinion. And if you've been in any litigation on employment law, you'll understand that. Now, that being said, for those of you who have never experienced an intentional tort claim that results from a workers' compensation incident or claim, you understand, or you haven't been exposed, that you will be told by a court on occasion that you intentionally meant to harm somebody. And let me give you an example. Under the workers' compensation system in Ohio, employers are supposed to be immune from civil liability, and that the employees are to be compensated for any losses through the workers' compensation system as the exclusive remedy for workplace injuries. Well, one out is if the employer acted intentionally, there can be what's called, quote unquote, an intentional tort that can result from a workers' comp claim. And just to give an example, if a manufacturer were to remove some sort of safety device from a press, and they knowingly did it, and they didn't get the safety device put back on a press, and an employee was injured on that press because of the absence of that safety device, you're likely going to catch an intentional tort claim. And I think the same is going to apply for COVID-19 claims. You're not doing anything intentionally to hurt your employees, but the law may say, well, here's our standard for what's intentional, willful, or reckless. And based on our standard, your behavior falls within one of those categories, and we're going to hold you liable. So keep records of what you're doing. Like Amy said, take the precautions, know what precautions you're taking and when you're taking them, and keep a record of it, because you want to be able to defend yourself in the event somebody says you did something reckless, intentional, willful, or wanton. Way of getting around the immunity from this House bill.
I think one example is everybody knows now that you're supposed to be wearing masks under certain circumstances inside buildings, especially where more than a few people are gathered. If you're not enforcing that on your employees, and you have an employee who gets COVID, they may be able to say, well, you didn't enforce any of these mask rules, and I may have gotten it at work. And so if you know better, and now you do know better because everybody's deluged with the COVID-19 rules, you got to follow them in order to get to be able to lean on some immunity here.
I think we're just about out of time, so I will go through this briefly. What's next? We can expect a lot more government grants to direct behavior of employers and to try to get money to those impacted, the employees and some employers impacted by the COVID crisis. We are also seeing a lot of government guidance. I've never seen more guidance, and I use guidance as a different term than laws and regulations. The CARES Act is a law. There are regulations that are passed to interpret the law. And then there is just guidance issued by the various administrative agencies. And a lot of agencies are administering and dishing out guidance that we have to pay attention to. That's not necessarily law, but it is guidance. And I would suggest to avoid any liability that you try to follow the guidance as best you can for your industry, because that serves as a defense to any claim of intentional, wanton, or reckless charges that you may face in the future. So again, we have to distinguish between guidance, laws, and regulations, but try to follow all. And the other item that I think is coming next, in fact, it's coming at a very quick pace within the last couple of weeks, we've seen a real uptick in plaintiffs' employment lawyers contacting employers and or suing employers for acts they think are in violation of the CARES Act. I've had 3 within the last 2 weeks that came up, and I see that as the next step. So you want to avoid litigating any of these issues and understand that you cannot retaliate against employees for taking any of the leave that they are granted under the acts from the CARES Act, and pay attention to your behavior and think about it. Is it retaliation for anything COVID related? And if you even have a question about that, call Amy or me before you do anything, because the last thing you want to do is be involved in a lawsuit. And even worse than that is a lawsuit that goes all the way to the Ohio Supreme Court and becomes the definitive rule about how COVID is handled. You don't want to be involved in that because the expense is outrageous. So communicating with your employees is critical, and try to keep good records about what you're doing, because the employment litigation related to COVID, it's happening, and it's happening now. We've got 1 case filed in our local district court and federal court. It's FMLA based, and it's COVID related. And like I said, I've gotten several threat letters from plaintiffs' counsel just within the last 2 weeks. So it is ticking up very quickly. All right, we've exhausted our time entirely, but Amy and I'd be happy to take a couple questions if you're patient enough to stick with us.
Great. We do have 2 questions that came in just as you were finishing up there. The first one comes from Julie Munson. This is specific to her business. It's, what about customers who refuse to wear masks? They provide masks, but they say they're disabled, can't wear them. We offer to bring food out to their car, but they claim we can't do that because it's discriminatory against them. And we tell all customers we can take food out to their car, you know, those who wear masks and don't wear masks. So it's a fine line, I think, is what she's saying here.
That's a very fine line, and you might even, I don't know what your signage is, Julie, but you might make your signage more clear that, or absolute. I'm sure it probably is, and there's always a few people who are going to try to violate something just to stir up trouble. But I would stick with your standards for safety, both for your customers and your employees at this time, and take all food, or make reference to that all food will be taken to the car and will not be served at the counter or wherever it may be on an internal basis. Amy, what are your thoughts on that?
I think I agree. I mean, if you're a private business, so you can set those rules as a business necessity to try to keep people safe inside your business, including your employees. And you've offered them a good solution. They can order anything off the menu they want, and oftentimes that you have it set up where you can order online and they take it out to the car. You may also, you know, if there's an umbrella company above you, you may want to consult with that company as well and make sure that everybody's consistently applying this across the board. I do think there's not a requirement to show any documentation if you have a legitimate excuse not to wear a mask. So you can't necessarily insist on seeing documentation either. I think that gets into some different territory. But I think it sounds like you're offering a really good option, and then refusing to serve them inside unless they wear a mask.
Right. They
to
just have
put-
to follow the rules.
Yeah, put this into context. As an employer, we're all more familiar with sexual harassment because it's been precluded by federal law since 1964, and we have a lot of case law addressing it. You as the employer are responsible for not only coworkers sexually harassing each other, but also from vendors and customers sexually harassing your employees. And I would think that would be the standard for COVID moving forward, that you as the employer are going to be responsible for the behavior of your customers towards your employees. So take the precautions that you can and document them.
Great. One more question here that came in. Lisa Kelly asked, are employers reimbursed for these potential 12-week paid leaves? Anyhow, if yes, how would we file for that?
The answer is yes, as long as you have that documentation we kind of mentioned. If you go to the Department of Labor, dol.gov, and then that question, the FFCRA question and answer page, and search for maybe documentation, or shoot me an email, aluck@rcolaw.com, and I can tell you what paragraph numbers refer to their bulleted list of information and potentially documentation that you should have as an employer so that you can later file that request for reimbursement. I just don't have them memorized today. I used to.
One more question came in here. Jimmy Fight asks, can an employer mandate employees secure a rapid COVID-19 test? I'm not reading that right, but can employers mandate that employees go out and get a rapid test? So I'm assuming rapid versus just find one on your own.
Oh, the type of test?
Mm-hmm.
That probably falls into that category of business necessity. If you know that person has had an exposure and you're paying for the test, you have to, if the employer is going to require a test, you need to pay for it, as opposed to allowing them to wait out some quarantine period. So I think it's got to make sense from a business perspective. If you're just across the board requiring employees to take the test, it has to make sense for each employee. But for example, I know a large employer in town who, once an employee notifies the employer of a potential exposure, that employer sends them to a specific testing site that they pay for that test, and then they have a right to those results. And that's how you get a quick answer.
Great.
But it's only after that potential exposure and the notification.
Right.
Well, thank you everybody for your attention. I'm sure we did not answer all questions. There's no way to answer all questions because we don't even know what all the questions are yet to answer as they relate to COVID. I think the best advice we can give is stay tuned. Keep an eye on the various websites that give summaries of information and status. For those of you in Ohio, watch the 5:30 press conference by the governor. I don't know if this is just a political look at me press conference, as some of them have been, or if it's going to be something that's substantive and addresses guidance or a change in Ohio's approach. So you just really have to pay attention. I can tell you the first thing I do every day is try to get updated on where the various agencies are with COVID and where the changes have come. And it's not easy to stay abreast of all of that. So we'll work through it all together.
This was very informative. You're getting lots of thank yous here in the chat section from everyone that it was helpful, informative. They liked just all the information, and someone, Kathy Rohde, your marketing person, is going to be sending that directly out to everyone by email so that you'll have access back to both Amy and Bill if you have a question for them, or anyone there at RCO Law.
Thank you, Kristen.
Thank you so much for this. This was amazing, great, and very helpful to everyone that attended. So thank you. Thanks, everyone. Have a great rest of the day.
Thank you.
Bye.